Good morning, ladies and gentlemen. We are about to start the second day of our conference, and the third panel will be devoted to reactions of international community on the case of Crimea. We'll have very distinguished speakers behind these tables. Starting from my left side, Professor Michał Kowalski, Jagiellonian University. Welcome, sir. Steven Blockmans, Center for European Policy Studies, Belgium, University of Amsterdam. Welcome. Professor Anatoly Kapustin, on my right side, Institute of Legislation and Comparative Law from Russia. And far right, extreme right, Dr. Łukasz Gruszczyński, Institute of Law Studies, Polish Academy of Science. I decided to reverse a little bit the sequence of appearance of the speakers. I know the abstract of interventions, so I decided to give the floor first to Łukasz Gruszczyński, because he would have the more general comments on reactions of international community, particularly concerning sanctions. Then I will give the floor to Steven Blockmans. After that, Professor Kapustin, and last but not least, Professor Kowalski. I will try to be very strict as far as the time is concerned. We do have 8 speakers in this session, and I would like all of them to fit into 15 minutes framework. With some tolerance, but no more than 2 minutes. Without further delay, I would like to give the floor to Łukasz Gruszczyński. Yes, and yet an additional technical comment. After these first 4 interventions, we'll have very short technical break, and we'll reshuffle speakers behind these tables. However, I would like to save some time for direct questions to the speakers of each part of this panel. So, sir, the floor is yours.
Okay. Thank you very much, Chairman. Good morning, ladies and gentlemen. It's my pleasure to be here today. I'm going to speak about sanctions and their assessment under WTO law. Okay, so this is how I'm going to proceed with the presentation. First, I would like to say a couple of words about what the economic sanctions actually mean. Then I would like to describe what kind of sanctions were imposed on Russia by Western countries, and by Western countries I mean United States and European Union. Then I will say a couple of words about the Russian reaction towards the sanctions that were imposed. And then I will move to the main point of my presentation, so I will try to assess those sanctions under WTO in order to answer whether they are legal or they are not legal. And I will conclude my presentation with a couple of observations. So when we are talking about sanctions, what we are actually talking about? Sanctions are defined as economic measures which are imposed by one country or a couple of countries on another country. And they can take different form. Sometimes they take a form of trade barrier, like embargo. Sometimes they take a form of restriction on financial transactions. Sometimes they take a form of asset freeze. And as we will see, all of them were applied by Western countries on Russia. The objectives of economic sanctions vary from case to case, but in principle they aim to change the behavior of the country, either behavior in the country foreign policy or either in the behavior of country internal policy. And I think for Russia case, it's clear that the intention is to change the behavior of Russian in terms of foreign policy. The legality of the sanctions can be assessed either under general public international law, and when I'm speaking about general public international law, I mean here general draft articles of state responsibility, but they can also be assessed within a subsection of international law, which is WTO, law of World Trade Organization, and I'm going to concentrate only on this aspect. So I'm not going to talk about a general responsibility of Western countries for sanctions. If we look at the WTO, from the outset it's visible that there is some kind of tension without deciding whether they are legal or not. The aim of WTO is to liberalize trade, to make trade easier, and obviously if you look at the sanctions, the aim of the sanction is to limit the trade. So there is at least a potential that sanctions can be violation of some WTO provisions. So what kind of sanctions were imposed by European Union and United States? So first of all, I would like to mention that they were imposed, and this is a direct quotation from the document of the Commission, as a response to illegal annexation of Crimea and destabilization of situation in eastern Ukraine. This is what the EU document says. They were imposed in different phases, from quite mild one, and with the time and with the deterioration of the situation in Ukraine, some additional sanctions were imposed, as well as the sanctions that were imposed previously were extended. So more people, more companies, stricter rules. So we've got different sanctions. First of all, we've got assets freeze and visa ban for certain identified people and companies. We also have a restriction on financial transactions, and European Union institutions are banned from entities that are registered and operating in the European Union. They are banned from buying certain financial instruments and providing loans to specific Russian companies. There is also an embargo on arms and related materials, and there is also embargo on dual use, so the materials that can be used both for civil and military purpose. And the last sanction is a prohibition on exportation of certain goods and technologies connected with the extraction of oil. If we look at the sanctions that were imposed by United States, they're very similar. Of course, there are some differences in terms of scope, there are some differences in terms of strictness, but generally they follow the pattern of European sanctions. So we've got travel bans, we've got asset freeze, we've got prohibition of certain financing of certain financial transactions. There are also restrictions on export of certain goods, goods necessary for the extraction of oil, for example, as well as goods for military purpose. Apart from United States and European Union, also some other countries impose sanctions, and this list includes Ukraine, Japan, Australia, Canada, Norway, and Switzerland, and it's not exhaustive. So there were also other countries that decided to follow the approach of European Union and United States. So what was the Russian reaction? The Russian reaction was to introduce a travel ban for certain US and EU individuals. They also decided to impose a restriction on import of certain agriculture products from United States and European Union. And they threatened, I mean not threatened, they announced that they're contemplating a case in the WTO, and this statement was made by very high officials, actually the highest officials on different occasions. So it was a Russian economy minister that said on several occasions that Russia is contemplating to bring a case against United States and European Union for violation of WTO rules. This was repeated by Prime Minister Medvedev, as well as President Putin, last time during the G20 meeting in Australia in November. So far, we didn't have a formal we didn't have a formal complaint. So in order to assess all those sanctions that I mentioned just a minute before, we need to answer 3 questions. So the first question is particular sanction subject to WTO rules? So is it possible to assess a particular sanction under WTO rules? If the answer is positive, the second question should be, so is this sanction compatible or not compatible with the WTO provisions? And if we answer in positive, saying that the sanction is incompatible with the WTO provisions, is there anything in the WTO law that can justify the sanction? So let me look very quickly at those questions. So the first question, can we attack, in a sense, or can we challenge those measures in the WTO? Do we have any rules in the WTO that would restrict or ban WTO members from taking such kind of sanctions? That depends on the sanction. If you look at for example, at the visa ban, it might be a case that they can be challenged under the agreement that regulates trade in services, which is GATS. However, only if you will find a specific commitment that was made by European Union and United States under its schedule of the commitments. I went through those commitments, and it seems that a possible challenge can come under a horizontal commitment which relates to the movement of natural person in connection with the supplying of services. Of course, you need to prove that this person is not able to travel to European Union or United States, and this person is providing a service. So obviously, this restriction will not apply to the visa ban which is imposed on public officials. They are not providing any services. As far as asset freeze is concerned, the situation is exactly the same. So you may try to challenge a measure under the GATS, so the agreement which regulates trade in services, if particular asset was connected with the provision of services. If this asset is a real property possessed by, let's say, one of the oligarchs, Russian oligarchs, it's very difficult to make any claim under the WTO because the possession of this asset is not really connected with the provision of any kind of services. But at least there is a potential for certain assets to challenge them under the GATS agreement. As far as the restriction on financial transaction, situation exactly the same. You may challenge if you will find a specific commitment made by European Union or United States with respect to financial services. Probably the most easiest thing to challenge under the WTO rules are import and export restriction on certain goods, and both, when I'm talking about goods, I'm also talking about arms, and I'm also talking about the equipment which is necessary for the extraction of the oil. So yes, in principle, at least some of the sanctions that were imposed can be challenged under the WTO law. So what kind of provisions are we going to use, and to what extent sanctions are really a violation of WTO law? So probably 3 provisions will be the most important. 2 provisions from GATT. Okay. 2 provisions from GATT. So the first one, the most favored nation principle, which says that if you give any kind of advantage to one country, you're obliged to extend this advantage to other countries. And obviously, if you impose an embargo or you impose a sanction on one country, this is a treatment which is discriminatory as compared to the other countries. The second possibility is to challenge a measure under Article 11, which introduced a prohibition of quantitative restrictions. And of course, embargo will qualify as a quantitative restriction. It's a ban on trade. So you could also try to challenge this with respect to Article 11 GATT. And the last article, most favored nation, but not with respect to goods, but with respect to services. And this will probably apply for any challenge that goes against the ban on financial transactions and asset freeze. So the last question, and probably the most important one, so is it possible for European Union, if the panel or appellate body, if there is a case, of course, will find that there is a violation of WTO rules, is it possible for European Union and United States to justify the measure by using certain provisions which are provided by WTO? And I think the answer is yes, it is possible. There is a special provision in the WTO which is called security exception, and And WTO law recognized that there are certain situations that countries can impose sanctions, not so much because of trade reasons, but because of some security reasons. There is not so much jurisprudence on this. There was no case decided since 47. Several cases ended up at certain level, but none of the case came to the final stage to the panel report. So in 47, 49, sorry, we had a case between Czechoslovakia and United States. This was rejected by the contracting parties. So the contracting parties said that the restriction or sanctions imposed by United States did not violate WTO law. A second case which came to the WTO was 82. This was concerned with the crisis between Argentina and the United Kingdom, and the European Union, as well as some other countries, imposed sanctions on Argentina. Argentina wanted to challenge those sanctions in GATT at that time. But this didn't end up with any report. And so on. We also have Nicaragua case. We also have Helms-Barton Act from '96. None of this case ended up with the report. So there is no jurisprudence on this issue. So how the security exceptions in WTO law looks like. I gave the example of Article 21, which applies security exception with respect to trade in goods. There is another article in GATS, which is exactly copy-paste, so exactly the same, Article 16 bis. And there is also an article in TRIPS agreement, so the agreement which regulates intellectual property in international trade, and which also repeats, the Article 21. So what we're interested here is that WTO law, Article 21, says that it's possible for the contracting country to introduce a measure, embargo, a sanction, if this country considers this as necessary for the protection of essential security interests taken in the time of war or other emergency in international relations. So what can we say, despite of the fact that we do not have any jurisprudence on this? What can we say about this provision? So first of all, it's all-embracing. So it can justify any kind of violation of WTO law. There is a disagreement whether this is self-judging clause, so whether a panel has any right to investigate whether there is emergency, whether it's necessary, whether this is connected with the protection of essential security interest. I believe that the panel has a right to review, and the panel has a right to look at the specific conditions of the security exception. But this is not entirely clear. So if you look at the preparatory work, if you look at the practice of the member states, it's not exactly clear whether it's possible to review. Assuming that it's possible to review, and I think this is supported by the text of the provision, as well as some systemic consideration, to have a loophole which will give a carte blanche to member states to impose whatever they want if they claim that this is because of security exception. I think this is not advisable from the point of view of WTO law. 1 minute, conclusion. So to conclude, so I believe that sanctions that are imposed due to security reasons can be reviewed by the panel. The answer to this dilemma, so how the panel should approach and applicability should approach, is to adopt so-called deferential standard. So the aim of the panel examination should be not really to examine to what extent the measure is necessary, to what extent there is a real situation of emergency. It should only manifest whether the assessment made by the member state is reasonable or whether there is a manifest error in the examination of which was undertaken by the member states. So if you take into account that the standard of review is very deferential, and if you look at the specific free conditions, and I'm going to conclude with this, if you look at the free conditions that are required by Article 21, I think it's quite easy to come to the conclusions that, first of all, sanctions are necessary. There are calibrated smart sanctions. There is essential security interest. So there is a conflict next to the European Union, which and NATO borders. So it also applies to the United States. And there is definitely emergency in international relations. There was invasion in Crimea and the stabilization of situation in eastern Ukraine, which can be subscribed to Russia. So I have no doubt that the panel will decide that the conditions of the security exceptions are met. Thank you very much.
Thank you very much. Rather, your questions will have short Q&A sessions after the first part of the panel. One additional remark to clarify, the term was used, the sanctions, but as it was also mentioned, we are talking about three groups of sanctions. Sanctions against individuals, that's one group. Sanctions sanctions related to the annexation of Crimea, and the third group, which actually yesterday was linked by the EU to the Minsk agreement. There are political and financial sanctions in this regard. Okay, Stephen. The floor is yours.
Thank you very much. Thank you very much also to the organizers for inviting me to this, what has been already a very interesting and gratifying conference. I should explain first that I come from a dual background, as you can see from my affiliations in the program. My day job is at CEPS, the Center for European Policy Studies, which is an independent and non-partisan think tank in Brussels, not affiliated to the EU institutions, nor any member state or political party. Part-time, I'm at the University of Amsterdam. And perhaps it's because of my policy background that the organizers have invited me also to shed a bit of a broader picture and light on the issues at hand, I think. I mean, whereas yesterday the discussions have revolved much around, you know, the human-centered principles of international law, self-determination, sovereignty, of course, leading to secession and war, which are important, of course, to discuss from an international legal point of view and understandable. I think, sadly, it also fits a dictator's agenda that we dispute amongst ourselves on these principles of law while obscuring what is really a clear-cut case of a violation of international law. Putin has whipped up Russian nationalist fervor and his revisionist ideologues and propaganda machine have used concepts like Novorossiya and the protection of Russians and Russian speakers abroad to convince the Russian population, first and foremost, of the just nature of their action. Quite effectively so, if we look at the Soviet-style popularity figures of Putin, as indeed also from what we could hear from Mrs. Voronin and Tolstik, who fielded all kinds of dubious arguments to justify what to my mind is an ordinary post-imperial land grab by a ruler who tears out a page out of a dictator's handbook, crushes dissent at home, appealing to traditional values and conspiracy theories, and restores international standing by fighting dragons abroad. I would offer a less human-centered but a more geostrategic and geoeconomic explanation for Putin's game plan. Energy interests and military domination of the Black Sea region. And as a second point I would like to make would be the legal regime which has been not touched upon much up until now, that is the law of the sea. First, in this area, the Black Sea region converge obviously several strategic interests, including those of Russia, Ukraine, Turkey, the EU and the United States, Georgia and the rest of the Caucasus. Now, given this prominent list of regional players, the Black Sea region, to my mind, is primarily of a geostrategic nature. And much as we may want to focus on the land of Crimea, I think the story is also, and perhaps even much more, about the water which lies beyond. Russia's annexation and ongoing militarization of the Crimean Peninsula could allow Moscow to take control of the entire region. For Ukraine, the loss of Crimea represents a significant decline in its military potential. It translates almost in the complete elimination of the Ukrainian fleet. And after the takeover of this Ukrainian navy, the Russian Black Sea Fleet outpaces, in fact, the Turkish fleet in the Black Sea, thereby becoming a major military power in the basin with the means of projecting maritime power even into the Mediterranean. Add to that the number of Russian military incursions in NATO members' airspace, as well as the number of planes involved in these incursions, which are on the rise. In November 2014, The Independent, a British newspaper which, unlike some of the Russian media controlled by the Kremlin, carries its name with deserved pride, published a list of 39 incidents of military encounters between Russian air and maritime vessels, and NATO forces and allies on the other hand, in violations of national airspace, and has caused, of course, several incidents where military confrontation or the loss of life was narrowly avoided. Last week, a list of another 27 incidents was made public, leading to a total of 66 close calls, near misses, and some violations of sovereign airspace and territorial waters between March 2014 and now. And that's a significant spike if we're to believe NATO in this respect. The reaction by NATO, of course, to the infiltration, occupation and annexation of Crimea has been Operation Atlantic Resolve, NATO's mission to check Russian aggression in Eastern Europe, which includes a 4,000-troop rapid response team that would have access to supplies pre-positioned across Eastern Europe. And of course, we've seen military exercises to back this up. Meanwhile, the United States is also establishing a missile defense base in Romania this year. Now, as to the role of the United States, I think, which has been famously exposed in this leaked recording of a telephone conversation between US Assistant Secretary of State Victoria Nuland and US Ambassador Piat. And while much has been made of the colorful language used by Nuland, the more important message contained in the conversation concerned the US role in liaising with Ukrainian opposition parties with a view to manipulate the orientation of the Ukrainian government in accordance with US interests. And what are these US interests? Well, if you read a recent US State Department commissioned report, it notes that Ukraine's strategic location between the main energy producers, Russia, the Caspian Sea area, and the consumers in the Eurasian region, Ukraine's large transit network and its available underground gas storage capacities, it makes Ukraine and Ukraine's overwhelming dependence on Russian energy imports is said to have negative implications, and here I quote, for US strategy in the region. In particular, the strategy of supporting multiple pipeline routes on the east-west axis as a way of helping promote a more pluralistic system in the region as an alternative to continued Russian hegemony. Now, energy is the sector in the Black Sea region where the geostrategic implications for the EU are most visible and urgent. The EU is notoriously dependent on oil and gas imports from Russia, as indeed the Middle East and North Africa, up to an estimated 70% of its total supply by the year 2030. Now, of course, Russia, as a supplier of energy resources, is equally dependent on its buyers. Its entire economy depends on energy exports, which is, of course, a huge vulnerability, as we've seen in the wake of the rapid decline of the oil price. And on the back of this decline, it was mentioned, EU and US sanctions, as indeed Russian counter-sanctions, they've reduced, as one commentator called it, the ruble to rubble. Now, Russia, too, of course, wants to diversify, hence the mega deal with China, the scrapping of South Stream to the Bulgarian coast, and the intention to work on Turkish Stream instead, to my mind, should be seen as a dual attempt to, on the one hand, punish the European Union while courting the Turks and finding new markets. we'll have to see what comes of that, of course. But what is clear is that the Black Sea region is a crucial transit area since about half of Europe's energy imports are expected to cross the region in the coming years. Now, to my second point, the juxtaposition of EU members and NATO allies, as well as Black Sea littoral states alongside Russia and Ukraine, creates an increasingly explosive mix, you could argue. And while the dynamics of the Black Sea region have changed dramatically, its governing conventions, as indeed its institutions, have remained virtually unchanged since the Cold War. And let me just take one example of conventions. I will leave the institutions like the Black Sea Economic Cooperation Organization and others aside. I'd like to focus a little bit on the 1936 Montreux Convention regarding the regime of the Straits, which gives Turkey control over the access to the Black Sea through the Bosporus Straits and the Dardanelles, and regulates the transit of naval warships. In April 1982, the convention was amended to allow Turkey to close the straits at its inception in peacetime as well as during wartime. And of course, the terms of this Montreux Convention have been the source of controversy for years, most notably concerning the Soviet Union's military access to the Mediterranean Sea, but also, of course, US access to the Black Sea. And amid the crisis in Crimea, Turkey authorized a US Navy destroyer to pass through the Bosporus, but noted that the legal agreement governing access to the Black Sea would not permit a US aircraft carrier to make the same passage, which is in line with what the Montreux Convention says, by the way. Now, the UN Convention on the Law of Seas, UNCLOS, which entered into force in November 1994, has prompted calls for the Montreux Convention to be revised and adapted to make it compatible with UNCLOS's regime governing straits used for international navigation. However, Turkey's long-standing refusal to sign UNCLOS has meant that Montreux remains in force without further amendments. And US concerns, of course, about Montreux ring hollow in the face of its refusal to sign up to UNCLOS. We all know that the EU and Russia, as indeed 165 countries, have ratified UNCLOS. One other point relates to the expansion of the territorial sea in the 200-mile exclusive economic zone off the coast of Crimea, which effectively cripples Ukraine's ability to access to open seas in the Black Sea, as indeed the operation of its economic operation in the region. If you look at the Treaty of Annexation of Crimea, there's one article, Article 4, Section 3, which contains a single bland reference, a sentence that international law would govern a drawing of boundaries through the adjacent Black and Azov seas. And as we heard yesterday, the Demarcation Commission that was installed only met once in 2012. It seems to me that Putin is in no hurry whatsoever in demarcating this process. As soon as the ground in the Donbass region is again fit, for tanks, he might attempt an assault at Mariupol and create a famous land bridge so as to unlock Crimea, thereby controlling the entire coastline of the Azov Sea and denying that problem of demarcation altogether. Of course, the floor of the Black Sea itself is a potential energy source, with ExxonMobil, Royal Dutch Shell, and other major oil companies already having explored the Black Sea and having done prospection, which shows that there's much more to be gained from that. So there's really a big energy game here playing out. And on the back of this, of course, we have EU sanctions, which partially touch upon the oil sector and the investment sectors of Russia in energy. Now, to conclude, I had more points. I think what becomes clear is that competition to dominate the Eurasian energy corridors are behind, or one of the reasons for Russian militarism, as indeed EU jockeying, as indeed US interference in the Black Sea region. These powers are motivated by the desire to ensure that Ukraine, which is of course a geostrategically pivotal country with respect to control of critical energy pipeline routes through the Black Sea region, remains in their sphere of influence. And while Russia's aggression is clearly a central factor to the sharp spike in geostrategic tensions in the Black Sea region, the US effort to roll back Russia's sphere of influence in Ukraine by other means in pursuit of its own geopolitical and geoeconomic strategic interests raises awkward questions. US oil and gas majors like Chevron and Exxon are increasingly encroaching on Gazprom's regional monopoly, undermining Russia's energy homogeny over Europe. Ukraine is caught haplessly in the midst of this accelerating struggle to dominate Eurasia's energy corridors. Thank you for your attention.
Thank you very much. So we've heard alternative reality a little bit to our legal considerations. Now the floor goes to Professor Kapustin.
Thank you. It's okay? Yep. You can hear me. Thank you very much, Mr. Chairman. And first of all, I would like to thank the organizers of this event, of this conference, to invite me to take part in it. And it is not my first visit in Warsaw. I was here almost 20 years ago in 1986, and I note a lot of changes and positive changes. It's very good, but of course I can see only some near places near the hotel and this conference place. When I think about this topic about the reaction, what's the title of this session, reaction of international community to the Crimea case. I think that it's necessary to resolve some theoretical questions to understand well what about we talk. I think it's necessary. So, first of all, I think it's very important question. It's what do we mean when we say about international community? The concept of the international community in modern sense began to be formed after the end of Second World War. It was be surprised, but in my mind, it is a very logical tie between the concept of world war, taking into account its destructive sense, and the feeling of unity of mankind, reflecting the notion of the community of all states of the world as whole. Of course, the term of international community doesn't occur in the Charter of the UN. However, it's quite often used in the resolutions of the United Nations General Assembly and decisions of the International Court of Justice. For example, only for example, Friendly Relations Declaration of General Assembly 26-25 of 1970 specified that all states use sovereign equality. They have the identical rights and duties and are equal members of the international community, irrespective of distinction of economic, social, political, or other character. I think this formulation is very interesting. In fact, it is possible to conclude that belonging to the international community allows the states to establish actual legal status in the mutual relations and with each other. In this sense, the international community is a legal one. It's in one sense little, I think. That is creating an important normative psychological prerequisites for peaceful coexistence of all the states. But despite the legal equality of the states, the international community is still tolerant to the existing distinction between the states. Therefore, it is impossible to recognize it complete or integrated. Rather, it is divided, because the national interests of some states are prevailing over the common interest of community itself. For instance, in some concrete situation, not at all time, but in some situation or in some events and so on. Of course, the term has his place in positive international law. In 1969, the term of international community received conventional fixing. Article 43 of the Vienna Convention on the Law of Treaties, devoted to the peremptory norms of international law, states that such norm has to be accepted and meet the international community of states as whole. Then the concept of the international community of states, of the states as whole, will appear in the preamble of the Statute of International Criminal Court in 1998. At the same time, the preamble of International Convention on Fight Against Financing of Terrorism of 1999 provides that financing of terrorism is a subject of serious concern of all international community. In Russian, we translate it like in Vienna Convention of the community of states as whole. But I think it's very interesting distinction between the two phrases or terms. From the sociological point of view, the international community is a natural product of historical development. In the framework of international community, the states provide the most important interests. For example, they can maintain international peace and security, to prevent war, to keep environment, and under certain conditions, to protect human rights. From the ideal point of view, interests of the international community shall not resist to interest of the individual state, but on the contrary, they should be the continuation. However, in reality, we quite often are witnesses of divergences of the interest of states and community in concrete situation. I said about it. I think if such a divergence becomes the historic and legal fact, the community has to make efforts for lawful source of means of settle it by peaceful way. Coercion's methods of application by passing the developed principle, norm, and mechanism of international law are critical. They, for a long time, can undermine a steady condition of international community itself and damage to the principle of solidarity, which is its cornerstone. Of course, the international community can't be panacea from the manifestation of undesirable policies of dictatorship, discrimination, hegemonies, so on, etc. It is known that World politics is formed by the main leading players of international community, large or great powers, some international organizations, etc. Anyway, the international community shouldn't seek for depending on the outlined split and seeks to find peace and at least favorable to the law decision, if it wants to develop and not degrade. The structure, the structure of international community is also discussed question, but I think in my mind, the principal elements are states. Regarding to the notion of reaction, we should state that it means different actions of the members of the international community in relations to some events, situations, and so on. Reactions by the nature could be unilateral, multilateral, lawful, unlawful, and maybe quasi-lawful. Some of them can be canalized in accurate international legal procedure, and by this this way they can have obligatory legal character. UN Security Council decisions, international courts decisions, and so on. Others, as resolutions, recommendations of the international organizations, only has moral or political nature and not have any legal significance. If to estimate from this point of view the realization by the Crimean people the right to self-discrimination in the form of unification with Russia, the international community reactions will receive the following picture. The certain part of the international community don't acknowledge the legality of the Crimean referendum. Many countries, including the USA and the member states of the EU and others, characterized the decision of Russia is annexation of the part of Ukrainian territory. A number of the international organizations and associations, including PASEA, Parliament Assembly of OCSE, Big Seven, and so on, adheres to the same position. The General Assembly of the UN adopted Resolution 68/62, the resolution in which declared non-recognition of legality of the Crimean referendum. But more significant as a result, I think, of this document, the results of voting from 193 member states of UN voted pro or in favor of this decision. 100 states contra, 11 refrained from vote, 58 and 24 didn't vote. That is in favor where only 100 votes do not support the document by different reasons, 93 votes. So 52% 2 and 4 and 84, excuse me, 48% against, or approximately. At the same time, there were states and the international organizations which recognized legitimacy of a referendum and the fact of reunification of Crimea with Russia. If it, for example, Armenia, Afghanistan states, Belarus, Kazakhstan, Kyrgyzstan, Cuba, Nicaragua, etc. Among the international organizations, it is possible to note such as BRICS, CSTO, and any others. Thus, it's possible to draw a conclusion that the international community as a whole doesn't take a uniform position of non-recognition of results of the Crimean referendum and reunification of the Crimea with Russia. Now, let me say something about so-called reactions or sanctions. We hear
2 minutes.
2 minutes, okay. I have 13 minutes. Okay. Mm-hmm. I think these sanctions or coercions themselves are not more than unilateral coercive measures taken by states or international organizations, and sometimes, for some reasons, I don't know why, call it sanctions. I want to stress they are totally unlawful, taking into account not only very interesting and sometimes professionally prepared legal evaluations of the situation, which unfortunately also have unilateral character, but not provisions of UN Charter or of other authoritative documents. Besides, they will not promote improvement of the situation in Ukraine and to the termination of the conflict in its southeast part. I want only a little example. 2 or 3 years ago in Sofia, I had my presentation of notion of the sanctions in international law. And I think the situation is not changed. I have the same strong position that the sanctions and other coercive measures should be taken only with, in accordance with UN Charter and other recognized international law norms. I think only one example, and I finished. I can answer the questions if you have. It's not legal. It's some dark side of the sanction situation. You know, in the media, I'm not economist, but it is very interesting data. During the last year sanctions, EU, as Spanish economist said, EU damage is about 21 million of euro. USA is $1.5 million profit. Very interesting situation, and we try to understand it. And unfortunately, some of our partners in Central Asia and Belarus and other countries also had damage, but Russia also had big damage, not like this. But I think it will be better to send such, or part of this damage, if it will not be sanctions or the relationship between Russia and EU is good. Some part of this money we could send to restore Ukrainian economy. I think it will be better. Thank you very much.
Thank you very much.
For your attention.
So now within the panel we have two colliding views on the sanctions. I mean, one speaker says quite legal from the point of view of WTO regulations. Mr. Kapustin says they are entirely illegal. So we will have debate afterwards. Now we will have a humanitarian law dimension to the issue. Professor Kowalski from Jagiellonian University. The floor is yours.
Thank you, Dr. Dębski. Also, I would like to thank organizers for gathering all of us here in Warsaw. Thank you very much indeed. My presentation will be devoted to the implications of the Crimean conflict for the international refugee law, or more precisely to some aspects of the problem. And as I'm a member of the Polish Refugee Board, which is the second instance body in the refugee status determination procedure in Poland, I'm obliged to declare that all I'm saying now does not necessarily represent the official position of the board. Now, as a result of the annexation of Crimea by the Russian Federation a year ago, a considerable number of people have fled Crimea, and most of them sought protection in other parts of Ukraine, but some sought protection abroad. And also, many people have left and still have been leaving the eastern parts of Ukraine, the Donetsk and Luhansk regions, because of the armed conflict pending there. And this is, of course, a great challenge first of all and foremostly for the Ukrainian authorities, but also for the international community as such, including the European Union. And some serious legal questions appear in this context as well, and this is what I would like to discuss now. And note, please, that I'm referring to the Crimea case as the beginning of the refugee crisis in Ukraine, but of course it is necessary to deal jointly with the exodus of people from Crimea as well as from the eastern parts of Ukraine. And it is especially so as the number of people who have fled the Donetsk and Luhansk regions significantly exceeded the numbers of people from Crimea. In that context, I would like to offer you some basic statistical data. UNHCR, the United Nations High Commissioner for Refugees, reports that as of March the 6th, 2015, just 2 weeks ago, the number of internally displaced persons, IDPs, exceeded 1 million and reached approximately 1,100,000 people. And these are people registered as displaced by the Ukrainian authorities. And these figures do not include approximately 20,000 people displaced in Crimea under Russian occupation. As far as numbers of externally displaced Ukrainians are concerned, they reach, again, as of March the 6th, 2015, 674,000 people, majority of which have left for Russia, more than 500,000 people, and more than 80,000 people have left for Belarus. Smaller but still significant numbers of Ukrainians left for the EU member states, and I'm going to focus on Ukrainians who applied for international protection in the EU member states, and not on all Ukrainians present in the EU member state. And this is important distinction. Note that, for example, since the outbreak of the Crimea crisis, 2,700 Ukrainians applied for refugee status in Poland, but 359,000 applied for employment permit in 2014, and it is more than 100,000 people than in 2013. So 2,700 Ukrainians applied for refugee status in Poland. Almost 3,000 Ukrainians have sought refugee status in Germany. 2,500 in Italy, 1,500 in France, and almost 1,500 in Sweden. So Germany, Poland, Italy, France, and Sweden are top 5 EU member states in which Ukrainian asylum seekers applied for protection. So in total, in all EU member states, the number of asylum seekers exceeded 11,000. And all member states received at least one Ukrainian application. And in my presentation, I'm going to focus on challenges faced by the EU member states in the context of the EU common European asylum system. Thus, I'm not going to enter the discussion on the legal status of the IDPs on the Ukrainian territory, and I'm limiting myself to say that Ukrainian authorities have made considerable efforts to meet international legal standards, non-binding international legal standards on the IDPs' treatment. Yet, the level of effective protection granting to the IDPs within Ukraine is crucial indeed in the approach to Ukrainian asylum seekers abroad. And this is so because what is a real challenge in a determination of Ukrainian applications for international protection in the EU member states now is the internal protection alternative, IPA, known also as internal flight alternative, and I will comment on it in a moment. The granting of international protection in the EU is governed by the EU asylum acquis, based on general international refugee law. And the asylum acquis consists of Dublin regulation, determining which member state is responsible for a particular asylum application, and a set of asylum directives. And here, key instrument here is the qualification directive, and its recast version was adopted in 2011. And under its provisions, under provisions of the qualification directive, any applicant for international protection in a EU member state is to be granted protection if he or she qualifies for refugee status or subsidiary protection. However, a member state may determine that an applicant is not in need of international protection when a risk of persecution or serious harm is limited to part of the country of origin only. So, an asylum seeker may relocate internally and avoid the risk of persecution or serious harm. And this is known as the IPA, internal protection alternative. So note, however, that internal protection alternative is also accepted under general refugee law and predates the EU asylum acquis. It's also accepted by the European Court of Human Rights in context of Article 3 expulsion cases. And in application of the internal protection alternative, four key issues may be identified. The first key issue: the internal protection alternative should be considered only if well-founded fear of persecution or a real risk of serious harm has been established in part of the country of origin. So it means that firstly an applicant must be in need of international protection, it must be determined, and only then the option of the IPA could be considered. The second key issue: this is the assumption that if state agents are the actors of persecution or serious harm or tolerate them, the internal protection alternative is unavailable. Third key issue, the third key issue, and this is really crucial: criteria for assessment of the conditions in the country of origin, in its safe parts. Of course, in context of the internal protection alternative availability. And this is about determination under Article 8 of the qualification directive, whether an applicant, I quote, can safely and legally travel to and gain admittance to that part of the country of origin and can reasonably be expected to settle there, unquote. And the fourth key issue: identification of safe parts of the country of origin. So now, concerning the asylum seekers from Ukraine, the first two issues I've just mentioned do not seem controversial. The Ukrainian asylum seekers from Crimea, including the Crimean Tatars, qualify for refugee status as they have well-established fear of persecution because of their nationality and or political opinions. Actors of persecution are Russian authorities and other actors supported by that authorities. And Ukrainian authorities are unable to offer any protection in Crimea. And Ukrainian asylum seekers from the eastern parts of Ukraine qualify for subsidiary protection as they are in a real risk of serious harm due to serious and individual threat to a civilian's life or person by reason of indiscriminate violence in situations of international or internal armed conflict, as Article 15.3 of the Qualification Directive states. And again, these are not Ukrainian authorities which are actors of serious harm. So, the critical assessment refers to the criteria for assessment of conditions in safe parts of Ukraine and their identification of the safe parts of the country of origin. And here we have serious problems. So, indeed, Ukrainian authorities, as I have already mentioned, have adopted legal framework for the protection of the IDPs, and they are entitled to be granted protection, and they are entitled to financial support, including the reimbursement of rent, and there are numerous reception centers for the IDPs, and so on. However, due to high numbers of the IDPs, 1,100,000 people, as I mentioned, the effectiveness of the protection may be put in question. And, for example, the IDPs they have serious problems to register as IDPs, and this is a condition sine qua non to be granted protection. As far as I'm informed, the situation differs significantly in particular regions of Ukraine, and I would be grateful if our Ukrainian colleagues could comment on that. What is also a serious problem for determination authorities in EU member states is the fact that the situation is very dynamic, and that what was the current one day is not necessarily current in the following one. So it is extremely difficult to get, and this is another problem, but this is extremely difficult to get access to reliable and objective sources of information. Even UNHCR and the European Asylum Support Office have problems in this regard. So there are also some other particular problems, for example, the hostile attitude of ethnic Ukrainians from the western parts of Ukraine to Russian-speaking only IDPs from the eastern parts. So let's take a look at that, what the practice of the EU member states shows. And in short, it shows chaos, and it shows completely different approaches to the application of the internal protection alternative and Ukrainian asylum seekers in general. According to the data from the European Asylum Support Office, as of the end of January 2015, the IPA is available, is applied by most of the EU member states. However, almost all of them report serious problems in the application process. Some member states have frozen applications from Ukraine. Such approach is taken, for example, by Belgium, by Germany, by Bulgaria, Norway, Sweden, Latvia introduced special procedures for application from Ukraine. What is also quite significant is that some member states are reluctant to share information with other member states. And for instance, the special meeting for asylum authorities from member states organized by the European Asylum Support Office in Malta earlier this way was ignored by the German authorities, not present on the meeting. Personally, I would claim that the internal protection alternative, maybe just 2 minutes more, may be applied to Ukrainian asylum seekers, but should be applied with great caution and with due respect for individual circumstances, for example, with due respect for rights of a child, situation of the ill, and other vulnerable groups. What is definitely needed? And these are concluding remarks. It's harmonized approach by all EU member states, coordinated by the EU institutions, including the European Asylum Support Office. And of course, strict coordination of member states is necessary in this regard. Otherwise, the common European Asylum Support Office will appear illusory, and the existing legal framework will remain empty. And what I'm suggesting now is that this is a true test for EU solidarity, and solidarity mechanisms such as the financial support from the Asylum and Migration Fund or operational support from the European Asylum Support Office are not are not enough. There are some other problems, but I see I have to stop here. So thank you very much indeed.
Thank you very much. Other questions?